конечно, Соликоры творчество вообще разработали. Я кричал, он как-то лахно думал.
Добрый день, уважаемые коллеги.
Good afternoon, dear colleagues. Good afternoon, dear guests of the session of our Dissertation Council. Allow me to declare our session begun and remind you to switch off your mobile phones. The Dissertation Board is called to order to consider the dissertation submitted by Ksenia Drantsova, legal regime for credit claim with respect to current payments in insolvency cases. The session of our Dissertation Council, according to Chapter 117 of the Decree on the Award of Academic Titles at St. Petersburg State University, the session is considered legally qualified. It consists of 5 members, including 1 international member who will be joining us online. 1 member of the Dissertation Council is absent. However, he presented his review to the dissertation following the established procedure. According to Clause 19 of the Decree on Dissertation Councils, as a chairperson of the Dissertation Council, may I establish the following time frame. The session must be complete within 2 hours. The session will open with my report containing the review of the documents submitted by the applicant, followed by a brief report of the defendant on the findings of her research. She will be allowed 15 minutes maximum. Questions will be asked as to the defendant's report. 10 minutes per question. The defendant will then address the questions received, after which reports submitted to the dissertation will be presented. Each review will be allowed 10 minutes. General commentaries on the thesis addressed to the members of the board will be made, 15 minutes. Next, an open discussion will be held. Anyone present at the event will be able to pose their questions or formulate their suggestions to the defendant. However, before entering this open discussion, the attendees must register and place their names on the list, specifying their name, their work position, their employer, the defendant will then reply to the comments from the audience. The responses may not exceed 5 minutes in length. Then the research supervisor will have the floor to make a statement, 3 minutes maximum. after which a 5-minute break will be declared before voting the defendant, the aspired academic degree. The discussion between members of the Dissertation Council will not be broadcast online. Next, open voting will be held with a count of vote and registration of the voting results in the minutes of the meeting. The session will be concluded by a statement from the defendant, which will be allowed 2 minutes maximum. Let us pass on to the first item on our agenda. As a chairperson, I must make a brief report on the documents submitted by the defendant. The dissertation by Kristina Drantsova. Legal regime for creditor claim with respect to current payments in insolvency cases. Was approved for defense as per the resolution of the Learned Secretary of St. Petersburg State University, issued on the 10th of July 2017. The Dissertation Council was approved as per the resolution of the Learned Secretary number 7358/1. The composition is as follows: Oleg Gorodov, Doctor of Law, Professor of Business Law Department, St. Petersburg State University, Chairperson. Olga Makarova, Doctor of Law, Docent, Business Law Department, St. Petersburg State University. Dmitry Petrov, Docent of Commercial Law Department, St. Petersburg State University, PhD. Gadis Gadzhiev, Doctor of Law, Judge of the Constitutional Court of the Russian Federation. Rahim Sadar Makhmat Gadir, Doctor of Law, Professor, Director of the National Presidential Legislation Center, the Republic of Tajikistan. The applicant, the defendant, submitted the following documents. Including application, degree certificate, report by the research supervisor, list of publications, certificate of postgraduate education, the dissertation in Russian and English, opinion on the dissertation, employment certificate. These are the key documents submitted as per the established procedure. All the submitted documents comply with Clause 12, Section 3 of the procedure for the award of PhD at St. Petersburg State University. Does anybody have any questions on the essence of my report? After no more questions, I would like to give the floor to the defendant, who will give a brief presentation on her study, on her research. Good afternoon, Mr. Chairperson, dear members of the Dissertation Council. First of all, I would like to point out that the subject of my dissertation is highly relevant. And it focuses on the legal regime for creditor claim with respect to current payments. The commencement of proceedings on bankruptcy does not mean that the organization will automatically stop its activity. The organization will bear certain expenses in connection with this activity. Creditor claims arising after the submission of the bankruptcy petition, called current payments, are payable, are first in line for repayment. As such costs are covered from the bankruptcy assets, from which the creditor's claims must also be satisfied, some conflict of interest is inevitable. Legal regulation of creditor claims on current payments must ensure a fair balance of interests of all debtors' creditors. This can only be possible if effective legal mechanisms are put in place to determine the reasonable size or the reasonable amounts of current payments in insolvency cases. However, there are some controversies and inconsistencies in legal regulation of public relations concerned with current payments. And here lies the relevance of our dissertation, of our study. Under the current economic context, the number of organizations declared bankrupt is growing. So the problem of balance of interests is becoming especially acute. The scientific originality of my research is that this is the first comprehensive study of the legal regime for creditor claims with respect to current payments and in insolvency cases. We have identified the key theoretical and practical problems arising with respect to such current payments. Some recommendations have been made to improve the existing legislation. Allow me to present some of the key conclusions drawn from the study. A classification of current payments is suggested. The claims may arise from labor relations, from money relations. Depending on their legal nature, two groups can be identified, two groups of claim. Requirements related to loan principal and interest, as well as claims relating to financial fees and penalty fees for offenses. Depending on the subject, claims may be identified as relating to the current payments of physical persons or legal entities, individual entrepreneurs, insolvency officials. Some claims may be given. Claims may also be subdivided as per their priority of repayment. Second, the study provides substantiation for the necessity to introduce amendments to the federal law on insolvency with respect to current payment estimates. The bankruptcy law must identify procedures for development, approval, and implementation of the current payment estimates. Information about any changes, any amendments to the current payment estimates must be included in the Uniform Federal Register of Insolvencies. Thirdly, the register, the procedure for register keeping must be determined as per the applicable procedure in insolvency cases. The register must include information about all creditors on current payments, on the grounds and dates of claims, on their priority and dates of repayment. This would enable the debtor to control the process of accounting and satisfaction of creditor claims on current payments. Four, the defendant deems it necessary to include the concepts of judicial expenses and insolvency cases in the bankruptcy law, including expenses relating to the payment of remuneration to arbitration to insolvency managers, including costs relating to including information to the Uniform Federal Register of Insolvency Cases, postal expenses, transport expenses, as well as other expenses covering the resulting from events arising from bankruptcy procedures. 5. The law on bankruptcy must include the statement that the employment of contractual workers involved in bankruptcy procedures and their salary adjustment must rest on the orders, decrees of the arbitration court considering the solvency case. Changes must be made to the priority of creditor repayments on current payments. The costs that are first in line for repayment are those that arise from activities relating to prevention of human and environmental disasters, and as far as the second priority claims are concerned, these include claims from persons who are working or have worked on the contractual basis, namely the claims relating to severance pay, compensation, and other payments as per the Labour Code. The study contains other conclusions and provisions, including proposals on improving the bankruptcy law. We suggest that the theoretical tenets and conclusions formulated in the dissertation may be used in further scientific research and reforming the legislation. Thank you for your attention. Thank you, Kristina. I would like you to remain on stage. Do members of the Dissertation Council have any questions regarding the report that they have heard? No. After no more questions, you can sit down, you can take your seat. And we will proceed to the second item, to the next item on our agenda. We will present the reports on the part of members of the Dissertation Council. The reviews have been duly published on the official website of St. Petersburg State University and are open to the public. So I would encourage members of the Dissertation Council to keep their presentations to keep them to the minimum and to focus on the critical comments. Because more often than not, the positive comments on the dissertations would be very similar, very typical. They are replicated, they're reiterated from one review to another. So let us let us focus on our critical comments. And the first speaker is Doctor of Law, Dmitry Petrov. Thank you. Dear colleagues, I have studied the work by Kristina Drantsova, and I think that the work is indeed highly relevant. It is reasonably well-founded. The tenets of the work are reliable. This includes the principles that the author tries to prove, the hypothesis that the author tries to prove. I have a really positive opinion of this dissertation. However, like any study, Ms. Drantsova's work gives rise to some questions. They have been outlined in my review published on the website. The author suggests that the estimate of current payments must be created by the insolvency administrator and approved by the creditors meeting, and if necessary, by the court. One of the points of evidence for this principle is the necessity to conduct or exercise control on this issue. The author quotes similar legal norms. For example, the current payment estimates of credit organizations, and however, this comparison is not very adequate because this position has some limitations. And this may also create some ground for ignoring certain current payments. It is possible to consider creating the payment estimates for claims, and I think it would be more sensible to use the mechanism of responsibility on the part of insolvency administrators for unjustified actions and unjustified calculations on current payments. So control over current payments must be exercised. Given these arguments, I would like to hear the author's opinion on that. As for the legal expenses on bankruptcy cases, including the procedures in insolvency cases, the author suggests the existing category as described in the existing law in Article 20.7 and including legal expenses, rename it to court expenses on insolvency cases. Correspondingly, in this case, I think that this statement needs additional motivation. You need to present arguments in favor of the statement. However, these questions do not invalidate the scientific merits of the study. The work is complete, original, It contains, it resolves numerous issues of importance to the development of entrepreneurial and industrial law and commercial law. In my opinion, the dissertation in question is compliant with the key requirements of the decree on the award of academic titles by St. Petersburg State University. And Ms. Kristina Drantsova merits the degree sought. Thank you very much. Thank you for your attention. Thank you, Dmitry. I would like to give the floor to the next member of our dissertation council, namely Dr. Olga Makarova, member of the dissertation council.
Dear ladies and gentlemen, of course my review is uploaded to the site of St. Petersburg State University, therefore I'll concentrate on the critical points, and I would like to say that my review expresses my very positive high assessment of this dissertation, because it contributes to the improvement of the legislation in the law of bankruptcy, namely, and but as far as the critiques on page 33, she talks about current payments, and the next page is characteristics or features of current payments, and so the notion and the characteristics are juxtaposed, and this is not a very good way of presenting ideas. And the next one is the classification of debtors' claims on current payments according to different criteria. And one of the criteria is the order of presenting claims on current payments. And so there's I would like to ask if there's any logic of the existing classification of laws of legal claims and the classification that the author presents. And also, I would like to say that, but on the whole, I believe that the dissertation is one that resolves the issues that are posed in the dissertation, and it resolves the issues that have to do with the bankruptcy law, and it merits the decision of St. Petersburg State University to grant the sought degree of the PhD in legal in law, and of course the concentration of this dissertation of this degree is 120003 civil law, entrepreneurial law, family law, international private law. And I would like to give the floor to Professor Rahimzada Makhmad Kadir, Doctor of Law, Professor, Director of the National Presidential Legislation Center of the Republic of Tajikistan. I would like to stress that the research by Kristina Drantsova on the topic of bankruptcy law is a valid piece of research, and my review is on the whole positive, and the dissertation manifests that Ms. Drantsova has completed a thorough theoretical survey, and also she presents valid answers to the questions that are posed in the research and in relation to the insolvency law. And also, I would like to say that some drawbacks are present in the dissertation. The dissertation focuses on reasonable claims, the debtors, but this scientific category of insolvency is not elucidated to an adequate degree. If the defendant looks at current claims, the item of 2 and 3 of the dissertation she recommends the improvement of the legislation that relate to the insolvency procedures. But we have to say that that there's a conflict between the creditors' claims and the guarantee for the creditors to return their loans and the legal rights of the workers. And so the defendant presents a set of recommendations and even goals that should be achieved. We have to have such a we have to reconcile the need to keep enterprises afloat, the bankrupted enterprises afloat, and of course meeting the obligations that the bankrupted enterprise has to meet. And therefore we have to say that the law on bankruptcy deals with this that the hard to hear what one of the most potent ways of control on the legal actions of the arbitration manager or the insolvency manager is the control on the part of the creditors. But and also we have to add here the oversight from the representatives of the workers of this enterprise, and so the arbitration manager should be put under more control according to the new regulations. The defendant talks about the need that it's important to that the arbitration manager is on the one hand a subject of law, and on the other hand an instrument, a legal instrument. So this point needs to be clarified. But on the whole, I believe that the dissertation by Kristina Drantsova is an independent piece of research, and it merits the granting of the degree of Candidate of Sciences in Law set out by St. Petersburg State University. And the author of the dissertation is deserves to be to have the degree of Candidate of Sciences equivalent to a PhD in the said field. Thank you very much, Ahmad Zabirovich. And the next item on our agenda is this. I would like to read out a review of the Dissertation Council member that's absent today. The author points out that the dissertation, that the defendant manifests a command of the literature and is versed in the legal practice, and the dissertation is includes all the legislation that has been issued in this field, and also, but there are some critical points in the review, and I'm going to read them out. Kristina Vladimirovna Drantsova tends to note in relation to legislation that the Supreme Court stipulations are don't find their way into the law. I would like to say, so what is the basis for such a conclusion? I haven't found the right theoretical generalizations that are necessary here, and the author restricts to, in her opinion, to the foundations of her opinion to the existing literature, to the opinions of others, and including Tkachenko, Fomichov, and others. In the process of studying the topic, Drantsova couldn't overlook the status of arbitration manager. And on the one hand, the arbitration manager is as a subject of law, and on the other hand as an instrument of law that is created by the legislator to resolve the bankruptcy case. And the author of the review says that drawing on the works of Alexeyev and Kubinsky, I cannot understand how a subject of law can also be an instrument. So then the next thing, that looking at page 2, chapter 2, the author says, of the review says, wanted to see some key statements of the Supreme Court mentioned in the text, and because the legal clauses should conform to the Constitution, and how they do so, and also some for example, the statement of the Constitutional Court of the Russian Federation dated 1605-20,000 is not cited, and number 12P dated 19/12/2005 is not cited either, and these are very important resolutions of the Supreme Court. And so they stipulate that the order of satisfying different claims, and they're based on inconsistent regulation, and the public duties that the arbitration the powers that are vested in the arbitration manager tend to reach the limits of this person being an individual entrepreneur. But in general, the author reaches the conclusions that are valid, and the recommendations are of practical and theoretical importance, and are of legal importance, and some recommendations and conclusions are, of course, reflected in some of the publications of the author of the dissertation. So, Kristina Vladimirovna Drantsova's dissertation on the insolvency and the claims in this area complies with the requirements set out by St. Petersburg State University that relate to the granting of Candidate of Sciences degree at the said university, and in this case the concentration is 1203, civil law, entrepreneurial law, family law, and international private law. And the next review is also positive. It is my review, and the dissertation focuses on the legal character of bankruptcy law officials that relate to current payments. The body of the dissertation relates to the topic that is set as the title, and of course it contributes to the theoretical body in this field. But of course there are some points I would like to raise in terms of questions that I have for the defendant. Well, I have two of them. The first one, I think that point 5 conclusions about that the hiring of a worker under a labor contract and the estimation of the salary should be the subject of the current arbitration court decision. And so how does it correspond to the labor code of the Russian Federation? And because I think the author here expands a bit the jurisdiction of the arbitration court. And the next one is the recommendation on page 108 that says that that she reformulates a clause of the bankruptcy law that says that we should change the order of payments, and we should put the payments that are geared to prevent technogenic and other catastrophe and public health hazards should be put first and in precedence of the other payments. And so, well, this is a controversial point, but it doesn't really demean the quality of the dissertation. And so, according to the regulations of this university on granting the SOT degree, the applicant deserves to be granted the SOT degree. And these are all the reviews that have been submitted from the Dissertation Council members, and there are no external reviews. So I would like to give the floor to the author of the dissertation for some comments that relate to the critical points of the Dissertation Council members. Thank you very much for all your critical points, and I would like to tend to them in the order of that they have been presented. Dmitry Anatolyevich Petrov, regarding the budget of current payments. I believe that the budget of the current payments can be an effective mechanism in preventing the abuse of power by the arbitration or the bankruptcy official, and therefore, because you could give instead of slowing down the process, it will give the power to the creditors to control any mismanagement of the funds by the creditors. And in terms of the different types of creditors and the notion, I present such a budget that have to relate directly to the procedures applied, depending on the execution and the membership of the arbitration management and other things. In terms of because if you look at the self-regulation, the role of the self-regulating organization and the predominance of this role in the oversight regarding the actions of the arbitration officials, I think this role is a bit overestimated, and it cannot be decisive. As far as the legal costs and the judicial payments, and whether these payments should be clearly defined in the bankruptcy law, I think this is a very important issue, because there are different categories of judicial expenses, and so there's a certain disarray in terms of how to apply this notion. So the category of judicial expenses in the bankruptcy case, in the narrow sense, clears up this gray field, and I elucidate this notion, and I of course recommend that this notion be included in the existing legislation. In terms of the different constituents of what these legal costs are, we leave this question open and needs a more in-depth study. Notion is a form of thinking. In terms of my question, I am now dealing with the question about the juxtaposition of notion and characteristic. And of course, notion is a form of thinking that includes distinct features of a particular class of objects, and of course characteristics are special features of this. And so I look on page 30 and 34 at the general characteristic of the current payments, and on page 34 and 36 I identify the concrete features of current payments. That would include monetary character of the claim, the date of the claim, etc. And also and now I would like to turn to Mahmoud Zabirovich. In terms of the current payments and the legal procedure on current payments are based on different legal relations, and this paper deals with these legal relations. And the question about the priority of preventing disasters, man-made disasters, etc. I believe that this is a public health issue, and therefore it should be put as a priority. But also it serves the purpose of giving guarantees to the creditors that they would receive payments, and maybe also prevent them from entering into legal relations or economic relations with potentially insolvent entities, economic entities. And also there are issues that are connected with protecting the property of the bankrupt, and this also has to be improved in the legal provisions of the existing legislation. The legislation regulates the order of claims, and we believe that there should be a balance between the orders, the order of the debtors, listed debtors, and also the debtors that claim current payments. There should be a balance there. And I think that there's no effective mechanism on the management of funds on the part of the management, the administration management. And so we have to put in a new new provisions to improve the situation. As far as the review statement about the lack of of different, statements of the Supreme Court related to the field have not been covered, but I would like to say here that these resolutions of the Supreme Court do not conform with the Constitution of the Russian Federation, and they do not really relate to the subject matter that I cover in my dissertation. Therefore, for example, the statement of the Constitutional Court of the Russian Federation dated 16/05/00 are not included in the dissertation because they relate to the legal status of the arbitration manager. And also, I would like to say that some, Christians were about that sources of some legal studies experts were not mentioned in my dissertation. Well, yes. This is a drawback, but I also can state that I cover many relevant research sources. Some legal procedures that relate to the decisions of the Supreme Court of the Russian Federation, the Constitutional Court of the Russian Federation, are really only statements that are of interpretative character, whereas I am talking in my dissertation that there should be some improvements made in the legislation, because this is what really matters in law. As far as the Dorokina's approach to the arbitration manager in terms of his status as a subject of law and as an instrument of law. The arbitration manager oversees the bankruptcy regulations and is a key figure in this process. It reconciles the conflicts of interest between different parties. But in order to allow this arbitration manager to perform his functions, there should be an instrument, there should be a foundation, and therefore in order to allow this arbitration manager to reach the desired goals. So the arbitration manager has a number of instruments in his disposals to achieve that. So the book by Dorokina, Legal Regulation in the System of Bankruptcy, talks about this approach to the legal nature of arbitration manager, and I use this approach in my dissertation. This is point 50. This is item 50 in the list of sources. And also, I would like to say that, of course, the statements of the Constitutional Court of the Russian Federation are very important, and especially dated on the 16th of May 2000 and also dated on the 19th of 12th 2005, that Gadis Abdullayevich Gadjiyev mentions in his review. They were not mentioned in the dissertation because the Constitutional Court of the Russian Federation deemed the Supreme Court statements as not conforming to the Constitution of the Russian Federation. And of course we cover some legislations of the Constitutional Court of the Russian Federation, namely dated 30th of July 2001 and 10th of July 2003. As far as the hiring of a worker that will be employed in the bankruptcy procedures and the role of the arbitration court in approving this hiring, I think that this does not contradict the labor law, because of course the hiring of this person will be guided by will be done in accordance with the labor law, but the estimation of the necessity to hire this person or the salary can be done by the arbitration court. I believe that the priority, another item is the priority of satisfying the claims that relate to the public health issues and preventing man-made technological disasters. Gives an important and additional guarantee to the debtors, to the creditors, that they would reclaim the loans. And of course, I recommend that the law on bankruptcy, the existing law on bankruptcy, be changed in order to reverse the order of satisfying the claims.
Thank you very much. I would like to request the audience, to ask the audience if they have any questions. No. The answer is no. In which case, may I give the floor to the research supervisor, Professor Vladimir Papantopoulou. Dear Chairperson, dear members of the Dissertation Council, my review has been submitted amongst a package of materials for the dissertation. In my opinion, the author merits the degree being sought. There are some controversial statements which probably can be improved on. However, this is only natural in a dissertation. There are no significant critical remarks that would seriously invalidate the compliance of the dissertation to the existing requirements. As a research supervisor, I request you to take a positive resolution on a positive decision on awarding the title, on awarding the academic degree. We have more or less exhausted the agenda. I will now declare a 5-minute interval. Will the members of the Dissertation Council please leave the auditorium?
Возможно, другие диссертации, как философия. Между Владимировной,
Итак, уважаемые коллеги,
Dear colleagues, I would like now to start the open vote. May I remind that the resolution of the Dissertation Council is considered positive if voted for by at least 3 members of the Dissertation Council. However, not less than half of the members. Mahmoud, how do you vote? I vote in favor. I vote in favor. Yes, in favor. Dmitry? I vote in favor. Olga? I vote in favor. I support you. I vote in favor of awarding Kristina Drantsova the degree. I would like now to give the floor to the defendant for a final statement, if you have any. I would like to to express my gratitude to my research supervisor, Professor Popentopoulou, and the Department of Commercial Law. Thank you for your understanding, for your assistance, and I am happy and honored that this 6-year project is now complete. Thank you very much. Thank you. I now declare the session of our Dissertation Council closed, and thank you for for participation. Thank you for your attendance.
Правильно.